Us Youth Law Australia, the Diplomacy Training Program and Australian Lawyers for Human Rights, and supported by child rights experts Dr. Noam Peleg, Faith Gordon, and Georgina Demopoulos. These webinars have been designed to build knowledge and understanding of the Convention on the Rights of the Child and to promote and facilitate the realisation of those rights, the implementation of the recommendations to the Australian Government in the concluding observations of the CRC Committee, and to raise awareness more broadly in the Indo-Pacific region and beyond. This webinar will focus on child rights strategic litigation. Professor Aoife Nolan will provide an overview of developments in strategic litigation, setting the scene, outlining the key issues, and talking about the Convention. Thomas, Kate, Caitlin, and Ella will then give a rundown of the Make It 16 campaign in New Zealand and their court case, the most recent instalment of which occurred only yesterday. The presentations will both then be followed by 30 minutes of comments and questions from you, our audience, and based on your questions posted in the chat function. Firstly, as is customary, may I say that Youth Law Australia acknowledges the traditional custodians of the lands on which we work, and we pay our respects to the elders past and present, and to the young people who are working towards a brighter tomorrow. Can I remind you all, please, to mute your sound and image. If I could also remind you that questions and comments should be made via the chat, please, at any time, and questions will be dealt with after the two presentations from Aoife and from Make It 16. And please pay attention to the chat because as our presenters reference particular documents and resources, those are very much likely to be linked in the chat and uploaded by Claire. So thank you very much, Claire. Without further ado, may I introduce Aoife Nolan. Aoife is Professor of International Human Rights Law and co-director of the University of Nottingham Human Rights Law Centre. Aoife is Vice President of the Council of Europe's European Committee of Social Rights. She has published extensively in the area of human rights, particularly in relation to economic and social rights and children's rights, as well as on constitutional law. Aoife currently leads a major 3-year research project focused on the theory and practice of child rights strategic litigation. Aoife Nolan. Thank you, Aoife.
Thank you so much, Matthew, and thank you so much to the organisers for having allowed me to take part in today's event. I've enjoyed a number of other seminars that have formed part of this series. I know that this is number 17, which I think is hugely impressive, given it certainly reflects a very high level of interest. And I have certainly enjoyed the work and the presentations I've seen as part of this series. Particularly, it has to be said, the one a few sessions ago involving the litigants in the Sharma case, talking about that particular experience. And I think that for those who were part of that seminar, some of what I say today, and of course, perhaps what some of Make It 16 will also have to say, will chime in with some of the issues and topics addressed during that seminar. So I'm going to now try to share my screen. Sorry, I say that in kind of a slightly optimistic way, but I am confident that I can manage this. Where am I? Yeah, famous last words. Here we go. Okay, so So I'm speaking to you today. I mean, I'm here as I'm speaking individually, but I'm speaking. What I'm speaking about is very much reflects the work of a 3-year global research collaboration that I'm involved in that's focused on advancing child rights strategic litigation. And what I'm going to talk, and this involves partners from Africa, from Asia, from Europe, and we have the work that I'm going to speak about today in particular has been developed by myself and a colleague, Anne Skelton, and with insights from various others. And I just want to be clear that I'm speaking, but this is very much a collaborative effort. So this research project has involved a number of different stages. first of all, we have the reason that we started a project at all was because, as everyone on this at this event will be aware, child rights strategic litigation has increased massively in the last 30 years since the adoption of the UN Convention on the Rights of the Child, okay? And I'll talk a little bit more about the reasons for that. But I think it's important, first of all, to explain what I mean by child rights strategic litigation, because there's a lot of different definitions and understanding of what we mean by strategic litigation, using the law to advance children's rights, etc., right? So just to be clear, for us, child rights strategic litigation is litigation that seeks to bring positive legal and social change in terms of children's enjoyment of their rights. And I can see to my complete horror that there is actually a typo in that first line, in my first slide, where it should say and or, because that's how professional I am at 9 a.m. in the morning. So my apologies. But basically the key thing to note there is it's not just about legal change, and it's also recognizing that you can have litigation that may not be successful, may have very limited legal impacts, but kind of massive social, political, or economic change, okay? So what are we seeing? We've done a whole mapping of global practice, and we're seeing strategic litigation being brought in a whole range of different legal contexts: national, supranational, civil law, common law, mixed systems. Everywhere we're seeing an increase in efforts to use litigation to advance children's enjoyments of their rights, okay? And we've seen a significant increase also in terms of the themes that are being litigated, the issues that are being litigated. It probably isn't going to come as a huge surprise to anyone that when child rights strategic litigation really, kicked off internationally, and by that I mean globally, there was a very strong focus on issues around, say, juvenile justice, child protection, family law issues. And since then, we've seen a distinct shift. This work is still being done, but we also see economic and social rights cases being brought. So, for instance, education has been a particularly important area there. And of course, I should stress that what is litigated is very much context specific, right? There are issues, we focus particularly on the national situation, and what you need to litigate in one place is not what you need to litigate in another place. And what you can litigate in one place is not what you can litigate in another place, right? So it's very much what's being done. It's challenging. We can map it, but it's challenging to draw comparisons simply because of the variety and diversity of legal systems and different challenges faced by children and those bringing litigation in different contexts. So, but economic and social rights was there was a shift. You're still seeing civil and political rights work being done, but you're seeing then, say, right to education, right to health, etc., etc. And then in the last 10 years in particular, you see children and young people acting as agents for their own change, right? So what do I mean by that? An obvious example is is some of the work that's being done around climate change. Not all of it. A lot of that is about children, and there's a lot of discussion of children's involvement in it, and there's quite a lot of posting about children, but in fact, it doesn't necessarily involve children themselves driving or pushing litigation. Other places we see, but some of it does, and some of it, for instance, the Sharma case is a brilliant example of children as agents for their own change. You have litigation being brought on sexual decision-making, the superb work that's being done on the right to vote, which I'm clearly not going to talk about because we have experts in the room. We have recognition of intersex children, sexual and reproductive health services. So these are really areas that in the last 10 years, just as these are only, speaking with my international child rights expert hat on, these are areas that in the last 10 years, the UN Committee on the Rights of the Child has really had to come to terms with. And it's interesting because the committee has had to come to terms with those issues because they're really pressing and they are a huge concern to children and their lived experience. And indeed, it's unsurprising that we see those same issues being litigated, being the subject of concern of lawyers, children, and other allies. You seem very interesting. There's a huge number of actors involved in child rights strategic litigation, law clinics, for instance, and the states where really strategic, oh my goodness me, sorry, what's happened there? Strategic litigation where so much, where the US, where so much strategic litigation has come from. Law clinics have been a huge player in this field, but they're also a massive player in, say, Latin America. to a lesser degree in European contexts, but a growing player in those contexts. You've individual practitioners, whether acting pro bono. You've got NGOs, international NGOs, national human rights institutions, for instance, children's commissioners, public defenders, lawyers associations, okay? And I mean, I can give you an endless list, but the key thing to note is that, for instance, 10 years ago, you didn't have discussions amongst children's commissioners about should they be bringing litigation, right? You might have had the odd conversation, but now, for instance, it's a major focus of the European ENOC, the European Network of Children's Ombudspersons. So we're seeing a real shift, a real growing awareness of the potential of strategic litigation when it comes to advancing children's rights. So why do we see an increase in strategic litigation? Well, first of all, there's obviously the growing profile of children's rights in domestic and international human rights law, whether it's advocacy or litigation, right? We see it everywhere. Children's rights are a hot topic in a way, particularly in the last 10, 15 years. There's an increasing understanding, both within, I mean, amongst the legal community, but more importantly beyond, you know, political community, society, of the particular issues that children face as a group, both in the here and now and in future as future adults. Okay, so there's growing awareness of that, and it's feeding in to a sense of urgency about engaging with those particular rights issues. There's also really important legal argumentation opportunities that you have with children's rights that you don't have with others, for instance. And I want you to think, if we think about the UN Convention on the Rights of the Child, you have a very specific set of protections that are that are particular to children and that adults don't necessarily share. And these, for litigators who are creative, who want to make a difference, who want to bring about legal and social change, this is a great opportunity. And even in countries, and I flag Australia here, where there is not enormous judicial enthusiasm for international human rights law standards, you still see there is a shift and a push and a discussion about this in a way that would not have been the case, say, 10 years ago, okay? There's obviously opportunities that we see from having children as a social group. I think to use a quote from one engagement we had around the project, someone described babies as the perfect plaintiffs. They're highly sympathy inducing. They present other complications apparently in terms of expressing their views, but definitely in terms of public sympathy and support, babies are good news. And I joke about it, but actually it's a significant thing. If you're dealing with an issue that is a subject of social conflict or controversial, if you have a sympathetic plaintiff, a child, then that helps you. Now, that said, there are, of course, groups of children that are highly unsympathetic or very negatively perceived. I'm thinking of children in the criminal justice system. I'm thinking of, for instance, migrant children who are frequently ferociously attacked in the media and very negatively portrayed or perceived by society generally. The other reason we're seeing this increase in child rights strategic litigation is frankly a growing understanding that as adults who work in children's rights, we need to support and advance the agendas of children themselves. Okay, it's not, it's the whole, nothing about us without us being applied to the strategic litigation context. And there's a huge issue with litigation historically about power differentials, about a rather paternalistic attitude being taken by, frequently white elite middle class lawyers. And I think just as that conversation has been had in strategic litigation circles more generally about the need to address that issue, that conversation is being had when thinking about working in the context of litigation involving children. And of course, I cannot underestimate the impact of the UNCRC, in terms of legal argumentation, in terms of shifting the cultural and legal discourse around children, but also the complaints mechanism, which I've helpfully put in an acronym that is not going to make sense to other people, but does to me. It's the third optional protocol providing for an individual complaints mechanism to the CRC. And the fact is you can't use that unless you take the domestic step forwards. Okay, and there aren't that many states that have signed up to it, but the fact is it has made people think about children's rights as a subject of litigation in a way that wasn't the case before. Okay. So anyway, so what does our project do? So in our project, we're taking a slightly, child rights strategic litigation has always been really good about looking at children's rights and thinking, litigators, and thinking, now how can I design litigation to target, say, government, politicians, different decision makers, to make sure that their behavior conforms to children's rights. Okay, and so what we're doing is we're thinking, our project is thinking about, it's not just about using children's rights as a lens to point outwards, where you think about what other people should be doing and how you as a litigator can push them to do that. It's actually about using children's rights under the CRC as a lens to look inwards and to say, well, actually, we're doing this work. It's it's about children, but is it in fact, are the things we are doing, are our engagements child rights consistent? Are we ourselves respecting children's rights, whether it be the right to be, children's right to be heard, freedom of expression, freedom from exploitation, you know, protection from physical and mental harm, or, you know, etc. And so essentially we are looking at, in our project, as children's rights under the CRC as a framework to inform and to shape the inputs, outputs, and processes of child rights strategic litigation. And we're working on the basis that the UN Convention on the Rights of the Child should play a key role in shaping and informing litigation practice. And we make, our view is that if you're doing child rights strategic litigation, but your practice isn't consistent with it, then that undermines the legitimacy of your efforts and, in fact, potentially affects the effectiveness of that litigation as well. Okay, so I'm very happy to talk about that a bit more. Matthew, can I just check, how much longer do I have to speak? I think.
Thank you, Aoife. We got off to a slightly late start, so about another 5 minutes.
Perfect. Right, I'll keep going. So,
thank you.
Which is normally queued for someone then speaking for 14 more minutes and, you know, completely blitzing the Q&A time, but I won't do that. But anyway, so this, I'm explaining what our perspective is, right? So this is great. So I think we can all understand, if you're talking about children's rights and you're working on children's rights, it is not entirely logical for you to be expected to do things that would be to behave in a way that is both supportive of and not undermining of children's rights. And for the academics on this meeting, many of you will be aware of, you know, child rights centered approaches or child rights based approaches to research. Those of us doing child rights research as academics have really had to think about this in terms of, you know, whether our processes and our engagements with children that we're working on or with in the context of research, and I use that language deliberately, whether our behavior is child rights conforming or consistent with child rights. And so what we're doing here is looking at what litigators are doing. So there are some challenges. First of all, the UN Committee on the Rights of the Child, which has done such amazing work, has said almost nothing about strategic litigation. And it has effectively said nothing about child rights strategic litigation practice. So there's not guidance there for litigators. We are not suggesting, let me be clear to the international human rights law heads out there, we're not suggesting the CRC imposes direct human rights obligations on litigators, right? We could talk till the cows come home about non-state actor obligations under the CRC, but that's not what we're arguing, okay? The fact is that it's very clear that the CRC is strongly state-centric. What we're talking about is rights as a frame that litigators choose to do. We're not suggesting they're required to in terms of international human rights law. Right, apologies for that, but I felt otherwise someone who does international human rights was going to go, but the UN committee does talk about in its work about the work of non-state actors. You know, it talks about doctors, it talks about, you know, tech companies, it talks about a whole range of actors, and it's spoken very little about lawyers and litigators. There's other challenges when it comes to thinking about how we put CRC rights at the heart of practice. Litigators working in child rights aren't necessarily human rights specialists, right? I mean, if you think about, and certainly you couldn't have a more really excellent child rights consistent practice, but if you think about the Sharma litigation, that's not a human rights case. That's a really well conceptualized tort case with human rights implications. And so potentially, if you have people who work, let me be clear, I'm not talking about the lawyers in Sharma, potentially if you have people working in areas of law that are not human rights normally, they're not necessarily going to be as aware of the standards and how they would apply to their own work. Similarly, you can have fantastic human rights experts who have very limited child rights expertise. And again, that may mean that when they're trying to think about what this means for their practice, they simply don't know how to do it. There's also the fact that it's tricky. You have a situation where some child rights strategic argumentation is incredibly technical, which makes, for instance, we have a big, strong emphasis in our recommendations on involving children in agenda setting around legal argumentation. And it can be very challenging if you're dealing with younger children and highly technical evidence. Okay, just give you an example. You also have the fact that child rights consistent practice, particularly where it involves support to children or engagement with children, can be quite demanding in terms of time, resource, and expertise. And lawyers don't necessarily have those things. Okay. Now, my suggestion in response to that is it's about developing partnerships, but sometimes it's not possible. And of course, there is, as always, when you're talking about child rights consistent practice, we know there are huge power differentials between lawyer and child clients, and that these are often exacerbated along race, ethnicity, class, and other lines of inequality. Okay. And so that's something that has to be borne in mind too when we're thinking about the relationships. But there are great opportunities, right? There is so much great practice out there, right? Now, the lawyers themselves may not say, oh, well, we had frequent, we ensured that we had round tables involving, psychological support for the litigants. They won't say, oh, we did that to ensure the child's right to protection from harm, but it's clearly that behavior is consistent with the concerns underlying the right to harm. So even where lawyers aren't necessarily expressly conceptualizing their work in terms of children's rights, they're often doing stuff that is child rights consistent. So there's loads of stuff out there. There's great examples. There's also very clear, and this is very clear from the extensive interviews and other engagements we've had with those carrying out litigation, about the need for the desire for upskilling in this area. People, if people feel there's a way they can do their work better, they want to do it better, right? These are people, good people doing good faith work, right? And so there is enthusiasm about bringing a child rights perspective on board. You also have this fantastic development in the last 10 years. You've always had child and youth movements, but now we recognize them. Think about working groups, associations in Latin America, etc. We'll talk to you about being marginalized while being a vibrant child and youth movement. But particularly with climate change, you have these existence of child youth movements that make children drivers and real collaborators in litigation in a way that simply wasn't the case before. And a brilliant example of this is equal education in South Africa. And finally, there's funding. Particularly if you work in, say, the climate change space, there are opportunities. And other areas as well. So I want to flag that. So I'm going to finish, and obviously there's much longer. There's what rights do we think are relevant? I can talk about the different areas they apply. But so what do I think we should do at this point? I think I'll share these slides. I think it's very easy to turn around and say, lawyers, you should be doing this, 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 and this, right? It's about starting small. It's about using partnerships and using the resources available to you to develop practice in a way that's child rights consistent. It's not about doing everything at once. And it's about drawing on mutual support rather than, we're certainly not interested in knocking people's houses down. It's about helping people strengthen their practice. It's about consciously engaging, thinking about, if I am bringing a case and it is about children's rights and it involves children, what should I be doing? If I look at the UNCRC, what does this mean for what I should be doing? And the other thing is, it's not just about best interest and participation. Okay, children's rights are very diverse. They speak to a whole range of challenges in the strategic litigation area. Okay, I'm thinking about things like exploitation. I'm thinking about things like the need for physical and psychological support for victims. I'm thinking of the right to information, for instance. These are all things that are relevant. And the thing is, and this is a shameless plug, join our network, right? The project has a network where we have a community of practice working on child rights strategic litigation. It's not all about child rights consistent strategic litigation, but a lot of it is. We have a big report coming out in September. And that it will just be transformative, but it will be useful. It will be a useful resource. And finally, I think, I want to talk just quickly come back to the UNCRC context. And in the context of this international complaints mechanism, we need to think a little bit about, when we're talking about child rights strategic practice, how can we make sure that where it's local and international organizations working together, that both sets of partners have children's rights at their heart of their litigation? And that's kind of an added complexity that's relevant to the third optional protocol work in a way that it isn't, I think, to the domestic. Okay, I'll leave it there. Thank you.
Thank you, Aoife, and thank you for those really practical suggestions about how we can all move forward in our child rights strategic litigation practice. I'm sure many of us will be joining up to your network and looking forward to that report in September, so thank you again. I'd now like to introduce the Make It 16 team from New Zealand. Thomas Pope-Kerr, Cate Tipler, Caitlin Taylor, and Ella Flavell. Thomas, Kate, Caitlin, and Ella are Make It 16 campaigners. Make It 16 is a non-partisan, youth-led movement to make the voting age 16 in Aotearoa, New Zealand. Among other things, they are taking a case to the New Zealand Supreme Court, seeking a declaration that a voting age of 18 is inconsistent with the right of 16 and 17-year-olds not to be unjustifiably discriminated against based on age under the New Zealand Bill of Rights. I give you Thomas, Kate, Caitlin, and Ella, and Make It 16. Thank you.
Good. I'll just start sharing my screen with you all, and I'll pass it over to Kate.
Kia ora, everyone. I'm Kate. I'm the co-director of the Make It 16 campaign here in Aotearoa, New Zealand. And I thought I'd just start off this presentation by giving a brief introduction into Make It 16. So essentially, we're a youth-led, non-partisan campaign aiming to uplift and strengthen youth voice in New Zealand by extending the voting age to 16. Make It 16 began in 2019 out of an event we have in New Zealand called Youth Parliament, which is essentially just a mock parliament event for young people aged 16 to 18. And youth MPs across all the political parties who were in attendance at that event agreed that the voting age should be lowered. Since that event in 2019, we've become a nationwide group of people passionate about making it 16. We have a couple different aspects to our campaign. We have an ongoing petition that's gotten thousands of signatures. We do a lot of grassroots campaigning, like speaking to MPs, speaking to members of local government. We do a bit of engaging with fellow young people, like going in and speaking at schools or speaking in youth councils. But most notably for the event today, we have a court case, which I will pass on to the next person to speak about.
Good. I'm Thomas. I'm from Make It 16. I'm going to talk a little bit about the sort of slightly more nerdy aspect of our campaign, and the technical stuff in the court case. So the basis of it is, the basis of our court case is the New Zealand Bill of Rights Act, and our claim that preventing 16 and 17-year-olds from voting, which of course is what a voting age of 18 does, is unjustified age discrimination. In New Zealand, our Bill of Rights Act, Section 19, protects against age discrimination, and it kicks in once you reach 16. And so fairly clearly, preventing 16 and 17-year-olds from voting is inconsistent with that. We also have Section 5 of the Bill of Rights, which is a general catch-all justification a part of it, which essentially sets up an ability for the Crown to possibly justify the limit on the right. However, the issue there being that the Crown has not presented any evidence that it is justified, and it's well established that they have the burden of proof that it's justified, and they haven't done that. And so our argument is essentially that the Crown hasn't met its burden, and the court should declare that it's inconsistent with the Bill of Rights. A key aspect of that is that in New Zealand, the Bill of Rights is not supreme law, and so the best the courts can do is declare inconsistency. They can't actually overrule Parliament's law. So that means we're seeking that declaration from the courts. We went to the Supreme Court on Tuesday as the last step there, and there's some photos of us outside the courtroom and afterwards with some of our lawyers there, which was a great time, and we had a good reception from the judges. So we're feeling quite good about the hearing, which focused mostly on a discretion issue around the Court of Appeal had already found that the government hadn't justified the age discrimination. And so we're only going to the Supreme Court because of that final hurdle of asking for that declaration, because the Court of Appeal found that they thought the issue was too political, and they didn't want to issue a declaration because they didn't want to step into politics. And so we've seen a lot of judicial restraint in New Zealand on issues like this before, and so this has a broader impact as well on the jurisdiction to try and create a better human rights culture in New Zealand. With that, I will pass on to Caitlin to talk a little bit about how the court cases helped us with the campaign.
Sweet. So my name's Caitlin. I am the communications, or one of the communications leads for the Make It 16 campaign. So I focus on basically the communication stuff and our social media. And so I'm just going to explain how exactly the case has really helped the campaign. And obviously the first thing is that it really did increase our publicity in media. We got a lot of interviews and a lot of press around the whole hype of, young people taking the government to court is a pretty big sort of headline. And we've even managed to have proper in-studio interviews, which you can see Kate there on News Hub Nation. Another thing that it did is improve our credibility. It showed people that we are like a strong campaign, able to take the government to court, and it really gave us a huge platform to increase increase the visibility of our campaign, basically. And then in turn, that of course increased our petition signatures as people were more aware of our campaign. And then it also started a better discussion around the idea of lowering the voting age, because what we found is a lot of people just have never even considered it and never even looked at the sort of arguments towards it. And then another thing that this obviously did has, even though we haven't got that declaration of inconsistency, it has likely sort of brought the conversation to our politicians and somewhat pressured them. And I think that has also resulted in lowering the voting age to 16 as a talking point or on the list of things to be considered in an independent electoral review that is happening at the moment. And we've also had a members bill that has been pulled, and it lists lowering the voting age on it, among a bunch of other things. But it's still really awesome to see that first step of it starting to happen in political conversations as well. And then there's just like a couple other photos, and I'll pass it on over to Ella, who will explain our key arguments.
Cool. Kia ora koutou, ko Ella toku ingoa. My name is Ella, and I'm the secretary for Make It 16. So mostly doing a lot of admin in the background to keep things going and taking minutes. But yeah, some of the key arguments that we talk about, and these are the main speaking points in the media, and when we're talking to people about the campaign, we sort of come back to those key points each time so that we have a consistent voice throughout our whole campaign. So number one is that voting is a fundamental right. A second one is that 16 in Aotearoa, you can drive, you can work full time, you can get married, for example. So you already have all these big responsibilities, and you can make these key life decisions, but you can't vote. So we like to sort of, point out that difference and what really is the responsibility and right there. Another is that age doesn't determine your intelligence or your political knowledge. A person's right to vote should not be contingent on their level of education or life experience either. In fact, I'd see it as a strength that you have different experiences and you're able to bring that different perspective to the table. Another is that there shouldn't be taxation without representation. So many 16 and 17-year-olds work, they pay tax, yet they have no say on where this money goes. For example, I was doing paid work at 15, paying tax, and couldn't vote until I was 18. Decisions that the government make today will undoubtedly affect the futures of young people the most, as we're going to probably be around for a little bit longer. And, feeling the impacts of the decisions made today, especially around things like climate change, housing, the economy, all of that sort of stuff really affects us. Another is that allowing 16 and 17-year-olds to vote would obviously allow for more people's voices to be represented in Parliament, which in turn creates a stronger democracy, and politicians will be more incentivized to actually listen to young people because, well, we get to vote on whether they are in their job or not. And there also sort of ties into the fact that there is evidence that the earlier you vote, the more likely you are to vote throughout the rest of your life. So overall, creating a stronger democracy with people of all ages voting once people sort of move through those age brackets. So yeah, those are our key arguments for the campaign.
Okay, that pretty much sums up our presentation. We're happy to go more in depth in certain parts if you wish later on in the questions. But yeah, that's it for us. I'll stop screen sharing.
Great. Thank you very much, Thomas, Kate, Caitlin, and Ella. As mentioned, please post your questions into the chat. And while you're doing that, I'll just invite Aoife.
Sorry.
Just invite Aoife to draw any comparisons or connections with your earlier presentation by way of questions to the Make It 16 campaigners.
So I think one of the things, I mean, a fabulous presentation, as always. I have to say, every time I Make It 16, it takes courage to share a panel, given how brilliant you all are, right? But I want to ask a question, because one of the key things we have found in our research, which obviously isn't an experience that you have had necessarily, is that while it's kind of focused on, a lot of it focuses on lawyer and child or young people relationships. And I think what I wanted to check was, you very clearly have a strong political, strong set of political aims. And so what I'm wondering is, when it comes to your work in strategic litigation, what is it that adult allies, and by, I know, adults, older adults, shall we say, adult allies can do in order to support your work? The advocacy work I can understand, write to your MPs, etc. But actually around the litigation work, did you find that there could be broader support? So that's one question about how older adult allies, sorry, I'm clearly feeling my age, older adult allies can support you. But the second thing I wanted to talk about was, this is such an important high profile piece of litigation, and there's been great media coverage, which is so important in terms of, as you said, motivating politicians. But I wanted to check, had you had situations of backlash? Have you had any negative impacts? Because that's something that certainly people who've been, children and young people who've involved in strategic litigation in other areas have experienced. There's been quite aggressive response. So two questions. First of all, role of adult allies, what should we be doing? And second of all, this issue of backlash, and how did you manage it if there was any? What were the resources you had?
I think one of you are going to have to elect to take that question. Who's going to put their hand up?
I can quickly talk to the sort of backlash element of it. Definitely have noticed some quite strong responses, especially around the court case from adults, and we often get them sent via email. So yeah, with our court case on Tuesday, very quickly received a few very long-winded emails about why 16 and 17-year-olds are not educated enough to vote, and how this would destroy our democracy, and that it would create a worse place for everyone. So definitely have seen that, and I think it's particularly elevated around the court case, because it is, something that comes up in the media a lot more once we're around that sort of time. And I think B, because people see it as sort of, a direct attack, that, you're going to the courts. Why are you, wasting taxpayer money to argue your case that you're going to lose, and all of that sort of stuff. So yeah, definitely have seen quite a strong backlash from certain groups of people around the court case. Yeah.
And to the question about what I guess the adult population of lawyers and support people can do better to support youth-led strategic litigation.
Yeah, so in terms of our campaign, obviously, in New Zealand, our ultimate aim is Parliament, because the courts can't overrule this in New Zealand. They can't make this particular piece of law, and there's very little that they can in New Zealand because of the way our constitution is set up. And that means that, you know, a lot of the work is a lot of the support that can be given is the advocacy stuff, signing our petition and those kind of things, and that's the key focus. In terms of the court case, you know, we've got a really good team of lawyers who are all working for us pro bono, and that's obviously always a huge problem for young people getting access to the courts is the money, because it costs a heck of a lot of money, and we've been able to get away with it because we have some people who are passionate and generous enough to give their time to us at no cost. So that's, you know, if there are lawyers out there, you know, that's the key thing, is if you've got the expertise, then as terrible as, you know, the access to the justice system is, you know, there's always the small things you can do just to give your time, because it's so valuable to the people who are on the receiving end of it.
Thanks, Thomas. A question in chat from Maria. Congratulations, Make It 16, for taking the case to court. May I ask how easy or difficult it was for you to instruct lawyers to represent you? I think it goes a bit to your answer just then, Thomas.
Yeah, it's actually been really easy for us, because we've had a really good legal team, and they're really nice people, and really passionate, and they've been great. It also helps that we have a few law students in the campaign who've been around for a little while, because, you know, the campaign's been around for a little while now, and have aged out of 16, 17, you're now at law school, and are able to kind of be the intermediary between the lawyers and the rest of the campaign, which has been quite good. And so I think that's probably helped a lot. But yeah, it's actually been all right. Hasn't been too bad for us. Yeah.
Great. And this question, I think, goes to Ella from Mia Tinza Kiao. What is the strongest argument, do you think, that the court would rely upon in the arguments that you presented upon? Are there any precedents that the court would likely take into account?
Yeah, I mean, I'm trying to think of a clear answer to that one. I think the legal case for us was very technical, based on whether Parliament should be making the decision or the court should be issuing a declaration of inconsistency. And the part of the case, another part of the case, was whether it was justified that, you know, 16 and 17-year-olds should be discriminated upon. And so coming into that are a lot of our arguments, saying, look, they can do so much already. Here we have the evidence from overseas saying that 16 and 17-year-olds in countries where they have been allowed to vote have, you know, had high qualities of votes. They've, you know, turned out in high numbers. It's not caused the world to crash and burn. All sorts of important evidence from those countries, I think, have been very, very convincing. And there's Dr. Jan Eichhorn. He's one of the main researchers in this area. We used a lot of his evidence. So I think out of those arguments that I presented, I think mainly the ones focusing on what 16 and 17-year-olds are already allowed to do under the legal system, and contrasting that to being allowed to vote, would be probably the most convincing for that justification element of our case.
Just as an extension to that, Ella, I'd be interested, was there a need for expert evidence in the case? You've mentioned international comparisons, might be one area. In these sorts of arguments, sometimes neuroscience enters the field to show that, you know, the developing brain of 16 and 17-year-olds is fully capable and competent to make such decisions. Was there an engagement with expert evidence in this case?
Yeah, so Thomas might have stuff to add at the end because he is our legal professional, but we did bring evidence. The Crown, however, did not bring that much evidence to the table. So we did bring evidence. We did actually talk to the point of sort of neurological development in 16 and 17-year-olds. And the evidence that we brought to the table was, hot versus cold thinking, I think is how you do it. So hot thinking is where a lot of younger people are still developing. That's sort of like, on the whim judgments, just quick decisions throughout the day. And that longer processed thinking is actually developed a lot earlier. And that's the sort of thinking that is implemented when you're making a decision, such as who you're going to vote for. And yeah, so that's an element of the evidence that we brought. So we didn't necessarily have to bring it, but obviously if we wanted to present the strongest argument that we could against the Crown, bringing that evidence to say, here's all the reasons why it's unjustified and here's the stuff to back it up, was really good from us. And the Crown didn't really push back with too much evidence in any of the courts from what we saw. Thomas, do you want to add anything?
Yeah, I was just going to say and you've mentioned it there. Really key thing though is that our essential argument is actually that the Crown hasn't done its job, and it hasn't brought any evidence, because, and you look at the Court of Appeal's judgment, and hopefully we'll be able to get Claire will be able to get that out to everyone. But you look at the Court of Appeal's judgment, and they've said, look, the Crown hasn't done its job. The Crown has not brought evidence that the voting age is justified, and the Crown has not fulfilled its obligations. And that's the key part of our argument, is that we're the only ones who have brought any expert evidence, and we don't even have to. So there's a really sort of failing from the Crown to try and justify it, and they've essentially just asking the courts to run away from the issue because it's too political. And we have a Bill of Rights, and it's set up in order to force the Crown to make sure that it's justifying breaching rights, and we need the Crown to be able to do that, and we need the courts to be able to declare that.
Thanks, Thomas. A question from Emily for Aoife, and addressing social security law within the context, no doubt, of your broad sweeping project, Aoife. As a social security lawyer, I'm interested in your thoughts, international examples, of using CRSL in relation to inadequate social security payment rates, poor access, or complete lack of access for particular groups, including children, and your views on the pursuit of public debt recovery by governments where that debt recovery causes financial hardship or poverty.
Thank you for that.
It's a big one, but it's a good one.
And I'm happy. I would suggest, actually, Emily, it's probably worth you emailing me about that, and I can throw some examples your way. I think there's very interesting with regards to access to social security payments, whether the amount being paid or groups being excluded. There's some really interesting stuff from the South African courts on this that's very positive. And then there's some recent cases which were child rights strategic litigation brought in the UK, the outcome which were very negative. So I think it's one of those areas where, depending on where you're litigating and what the attitudes are with regards to governmental discretion when it comes to social and economic policy, it'll make an enormous difference. So I think whatever examples you get, you yourself will know the context in which you're litigating. But I would say I'm not sure how transferable examples from other contexts will be, given that in most countries the judiciary has a particular take on social and economic policy. There was a second part to that question, and it was on debt repayment. I don't have an immediate response to that, but if you drop me an email, I can take a look. I want to just very quickly come back in here though, because I want to just pull back to something that Thomas said earlier on. One of the key findings that we have with the project is that intergenerational bridging is really important. So, you've got, so for instance, we've seen situations where strong intergenerational connections and alliances has led to things like the identification of clients for the purposes of child rights strategic litigation. But it's also, and forgive me, Thomas, and make it 16, but I think you may have used this example previously, that the fact that you have people who can speak to older adult experts who are not great at communication and are able to take that and make it digestible to an audience that frankly, might be younger and with less experience of the legal system than you yourself had, that this intergenerational bridging was very important in terms of effectively communicating what had been decided from a legal perspective. I mean, is that fair, Thomas? And I'm sorry, I'm flagging Thomas not because he's the only speaker, but just because I think he made the point at a previous acquittal meeting. And I think it's a really interesting example because you see quite a number of organizations where, particularly where there's litigation, but there's also media and advocacy, broader advocacy and campaigning work with children, where you have very young communications officers, for instance, where there's a clear, particularly this is an area where children and young people are involved, but there's a real, you can see the pivot between the older technical experts and then kind of this bridging effect with younger people. And I wonder if that's something that I'm misremembering, or if it's something that I have correctly from your experience.
No, you're remembering that, and I remember making that point at a meeting. And Cate is our primary spokesperson in the media a lot of the time, and has done a spectacular job of media work, and being able to kind of take that through. And as I said, we've got a couple of little students, and that kind of intermediary does help, being able to have a foot in both worlds, while perhaps not understanding either fully is helpful. So yeah, you're absolutely right. I wondered if Cate or someone wanted to add anything, but yeah.
No, I will just add that probably is one of the most helpful parts of the campaign from my perspective as a 16-year-old who does a lot of the communicating for Make It 16. Having people like Thomas in the campaign who are able to communicate between us and the lawyers and make the legal arguments digestible for me to turn into sound bites and speak to the media is actually a significant part of why our campaign is so popular in the media and in New Zealand, is because we're able to be accessible.
So interesting. Thank you.
Thanks, Cate. I might ask you to extend on that, if I may. Strategic litigation, we can look at it in isolation, but clearly you've looked at this as one of your campaign strategies around Make It 16. And I guess a question for you, Cate, and also a response, Aoife, from you, please. To what extent is strategic litigation inextricably bound up with good strategic campaigning? Can you have one without the other? Cate, you first, please.
I think in terms of our case specifically, the court case has been hugely helpful for us, not just from the perspective that obviously getting that declaration of inconsistency would be a massive help for the campaign, but because that's what people find interesting and that's what gets us in the media. So I don't think we'd be able to do the other parts of our campaign, whether that's being invited to speak on panels like this or speaking to young people in schools or that kind of work, if we didn't have the court case as the base of our campaign. So I think that's where going to the courts is useful as well, because it's a huge deal, especially when you make it to the Supreme Court, and it means we're able to do the other parts of our campaign as well.
I'm sorry, this is so appalling, but from another previous event, I do remember Make It 16, you talking about how going to court meant you were taken seriously, right? Because you were going to court, and it's a big thing. I mean, it's weird that would be the thing, but it is definitely, it sort of legitimizes and concretizes a campaign that otherwise is just another campaign. And that's, of course, not just true when it comes to child rights strategic litigation, or young people strategic litigation. So I think you were asking me, advocacy can be really important depending on the context. It's obviously super important to the Make It 16. It's a lot less important in situations where the courts have broader, stronger powers. And where, I mean, that said, you can have a situation, for instance, where there's I mentioned them earlier and I use it because they're a useful example. They have a great website, Equal Education. They talk about their work, where during COVID-19, it's a social movement with very active engagement and involvement of children and young people. Equal Education they decide what's going to be litigated. That issue is then the broader movement, the issue is litigated by the Equal Education Law Centre. And what happened in this case was it was about COVID and the pausing of a school nutrition program, effectively. So school meals, as we all know, in many countries was a problem during COVID. Schools reopened, the nutrition program wasn't reopened, litigation was brought, they won. But nothing happened. So what you did see in that case was, even though you had a brilliant legal judgment, follow-up and advocacy in that context was really important. You know, so you had children, for instance, reporting from their classrooms, which was fed back in by Equal Education into reports back to the court. When the government was saying, oh, we've done this and this, they were like, well, actually, a 14-year-old in, you know, KwaZulu-Natal says this isn't happening. So I think it depends on the situation. You can definitely have strategic litigation without political advocacy that can work, and that's to do with the particular context you're in. But, you know, a lot of strategic litigation reflects systemic problems, and there's a pre-existing campaign. There's a reason it doesn't come out of nowhere. Yeah.
Thank you. I think we just have time for one more question and then a wrap up. I wonder, before we get to that question, if there are questions left unanswered, if our speakers would mind if we emailed them through to you to obtain an answer for the individuals whose questions will be missed out. We've got a lot of them, but this is the last question for the evening. A developing general comment of the Committee on the Rights of the Child is being made at the moment on the right to the environment with a special focus on climate change. Nick asks, in light of the Sharma case and other climate change related children rights strategic litigation, do you consider the emerging general comment to be an opportunity for the committee to consider and provide more targeted guidance for litigators and children's access to climate justice through litigation? What, if any, recommendations would you make to the committee to shape the new general comment from a strategic litigation perspective?
So I'm going to be slightly controversial here. The general comment covers a lot of issues. Climate litigation is a really hot topic, but we're not going to solve climate change through litigation. And we're going to need wide-ranging governmental change, and litigation is really good at tackling post-facto problems and not as great at dealing with long-term preventative measures, right? And there's a reason why we tend to turn to democratic institutions that have both the power and responsibility to do that. Okay, so what I would say is climate change litigation has been incredibly important, but when it comes to climate change, it's just part of a bigger picture. And I'm part of the advisory committee on that general comment. And one of the interesting discussions has been the extent to which the focus on litigation should form an extensive part of that comment, right? Because should we be giving time to strategic litigation, or should we be focusing on fleshing out what intergenerational equity is in the context of children's rights and environmental protection more generally? I'm not suggesting for a second that climate litigation isn't important, but actually I think the general comment, that's about, you know, it's access to justice, it's about remedies. I don't think it should be a dominant feature of the general comment. The general comment has to be about setting the space and making clear, in my view, what children's rights have to say and what they mean in terms of what governments need to do in a wide-ranging way around climate change. So a bit of a child rights strategic litigation is really important, but it's not necessarily, certainly not a panacea in this context. And of course, I'm not suggesting the question asker thought that either.
Thank you, Aoife. And I think you made that point marvellously about the sometime limits of strategic litigation. Of course, it's those very limits that Make It 16 have addressed through both the litigation and in concert with a very considered campaign. Ladies and gentlemen, we're about to close for the evening. If I could ask you to put your thanks in the chat for our speakers. I'd like to thank Aoife, Thomas, Cate, Caitlin and Ella for joining us from diverse points of the globe. I'd like to thank you all for joining us. Today was a really broad international audience from all parts of the globe, and we thank you for tuning into our webinars. We hope you find something in them, even if occasionally they have an Australia centric focus. Ladies and gentlemen, our next webinar will be in August. At this stage, topic and date to be ascertained, but you will all be emailed with that. And on behalf of Youth for Australia, the Diplomacy Training Program, Australian Lawyers for Human Rights, and our experts, Georgina Demopoulos, Noam Peleg, Faith Gordon, as our expert advisory group, I thank you for joining us. Wherever you are in the world, good morning or good night. Until next time, adieu.
Thank you so much.
Thank you.